How did you maneuver all this to start having clans?
A son in a family where you get everything in your father's homestead, and then you now say, I want to go start my homestead.
Yes.
Yeah, automatically there must be those teething problems, the challenges. Yeah, the setting up factions.
Yes.
They join a faction and they buy the faction.
Yes.
And where at that time, there was this very dangerous politics that was going around, that was pitting in big players versus the small players.
So, what would you say is the main problem why people have objections to the revised constitution? Or no, what was the main ground?
I think if you ask me, it is not even about the people.
Okay.
I think we had a section of the leadership
Okay.
that maybe they felt uncomfortable with some of the provisions which were passed.
Okay.
But to realize that if people, because the amendment process was properly done in both branches, it was endorsed by over 500 members, and it was passed. You know, as a leader, if I come into leadership, it does not matter the wisdom. Maybe if you feel the people pass it had the wisdom, or they lack the wisdom, so you want to use the opportunity to have that thing expand or search flimsy ground. I think the best thing that ought to have happened is that once the amended constitution was registered, the best thing that was supposed to be done was, as a leadership, initiate maybe amendment process for some of the provisions that you feel that maybe they are not properly aligned, and convince the members on why you feel they need to be amended. So I think that was one of the challenges that we faced.
I think it would be good for KIFWA members to be able to appreciate the cost of not having a properly endorsed constitution, because then it denies them many other opportunities, even representation. For instance, as the trustees, you find a situation where KIFWA would be working with one trustee instead of 4 trustees because of that. And I think that's a challenge that would go to the leadership. Now, I know that you are also studying law, and I think that would be an advantage to KIFWA. Are you able to share the membership how you have used that knowledge to represent KIFWA as the national secretary and the members who are affected by the laws? How are you using this knowledge?
Thank you very much, Senior. Maybe before I come to your question, one thing prompted me to be very curious in matters to do with the law. You remember that as customs agents, we are governed by the East African Community Customs Management Act, 2004. There was a time I was penalized. My client was penalized for a mistake, for an offense that maybe when we came to realize it later, we found that there was no basis or ground. So I think with that, it prompted me to have an interest in looking at what does this ECMA really mean, the provisions that it gives. And that's how my interest now to do law, plus what I told you earlier, that it was an aspiration that I had before emerged. So I think there are quite a number of things that maybe have given to the association pro bono service. One example, the issue of vetting of the customs clearing agents. The vetting, the commissioner had the right maybe to control the agents, the conduct, the behavior, and I'm very much happy that KIFWA works very closely with the Office of the Commissioner. We have very good collaboration in addressing matters to do with the members' challenges. In 2010, because ECMA was enacted in 2004, Kenya got a new constitution in 2010. So if you look at some of the provisions that are contained in ECMA in 2010 and post-2010, they're very much not in sync. I'll give you an example. If you look at section 145.3, of ECMA 204, the Commission has the power to cancel, to revoke, to suspend, or to fail to issue a customs license to any agent.
Okay.
That used to happen majorly, a lot of them pre-2010. With the advent of the new constitution of Kenya 2010, it created more rights to every citizen. One of them is the right to fair administrative action under Article 47. So we've looked at many, I've taken my time to look at many provisions, interpretations on how the courts now interpret. One example, it is very difficult now for the commissioner to just come and suspend or cancel somebody's license without giving them that fair administrative action process. So when it comes to the vetting issue, I looked at the grounds that were used because the vetting process was just left to run. I remember there's an agent I was looking at from the research I was doing. There's an agent who tried to stop the vetting process, and the lady justice who was handling the matter dismissed that application, and not because the process was right or wrong, but because ECMA has given appellate processes up to 229 where anybody who is affected by the actions of the commissioner can use from the appeals, the reviews, all the way to the tribunal, tax appeal tribunal, and the courts. So after this process was done, as you remember, we received quite a number of members who are very much dissatisfied with the rejection. Somebody will tell you that they've been in practice, they've been licensed for the last 20 years. Yes. Then you subject them to a vetting. Then you tell them that they failed because they didn't have adequate knowledge of customs. So if you get such a reason, you want that. Yes. If this person has been having this license for 20 years, how then does it mean now their knowledge
suddenly they don't have the knowledge,
suddenly diminished? The others, other reasons that were used there. Another one may be compliance with domestic taxes. Okay. But that's a very interesting area. Maybe as we proceed, we'll
talk about that. Yeah. But I want to come in on that point that you're discussing. Yeah. When we developed the Mombasa Port Community Charter, one of the things that we really fought hard for to be able to put into the charter was accountability on the role, on the part of the people who facilitate trade. And for instance, what happens when the clearing agent has done the correct documentation, but customs takes time to pass the entry, and to the extent that the cargo now incurs storage and demurrage. Okay. Can customs be held accountable either for negligence or just being, for the lack of a better word, inefficient in processing trade?
Thank you very much, Senior. Maybe as well with the licensing is a matter that we addressed the commissioner, and I'm very much happy. She was very positive in the response that we gave and the legality that concerns that we raised in relation to it. Okay. Now, coming to your question, it is true. There are many violations that happen, maybe in the course of our work, because you realize that as a consumer of a service, yes, agents are consumers of government service and private businesses, services of private business entities. So if you look at Article 46, for example, gives these rights of a consumer. We even have our own legislation, the Consumer Protection Act, that guides you. So if these violations are done to you, the onus is now on the person who has been affected to pursue the legal mechanisms on how they can be compensated, yes, or on how this breach can be addressed. But a violation will happen and you don't pursue it, maybe you complain, it will just end at the complaint. That's why we are told that even courts, they will see a violation happen, but courts don't invite themselves. It's the parties, the disgruntled parties that will go.
Isn't it now the responsibility of KIFWA to educate its members and help them to recover the cost, because the owner of the cargo will say, I gave you the documents on time. I gave you a complete set of documents, okay, on time. I was not responsible for negotiating with, I pay you an agency fee to represent me. So therefore, he will not accept that demurrage. He will not accept any storage. And he has the last signature on your check.
Yeah, I think maybe that I agree with you. Number one, the best thing that needs to happen, I think this challenge, maybe from where we come from, we normally have a saying that at times when your chicken is attacked by a mongoose, at times you must blame the chicken. What did it go? Why did it go to the bush? And also blame the mongoose. Why did it just come to my compound to take my chicken? So this is a two-dimensional approach, answer to the question. Number one, I think the biggest mistake, or maybe the mistake that most of us make, we enter into contractual obligations for customs clearances or consignments without valid contracts. And this, I think, it affects quite a number of agents.
Yes.
And these are something that KIFWA, we have taken it. For example, we have had several dinner meetings with the directors. We even brought professionals to advise us on how are you supposed to enter into contractual obligations. For example, if you had a contract and in your contract it's well spelled out, maybe that the liability of the agent, as your agent, will be affected by factors A, B, C. For example, for a downtime of any system, because systems are things made by human beings, they can have downtime. So if it is not well spelled, that for downtimes the agent is insulated from that liability, there's nobody will pursue you. But in instances, some of the members that we talk to, you give a quotation to a client, they give you all the money. You've demurrage, port charges, whichever, you go clear, no communication is given, automatically they must.
But Madam Secretary, you are not being fair to your member. And the reason why I'm saying that is your member has done his part. Okay? He lodged on time. Okay? The declaration is correct.
Yes.
But these governmental departments, okay, are the ones who are causing the delays. At the end of the day, the matter remains between the clearing agent and his client. Okay? And the client is saying, no, I'm not responsible. So you're leaving your member vulnerable. What I'm saying is, why haven't we, as KIFWA, taken it up with the government based on our charter with them, that whoever is at fault will be held responsible? So that why would a customs officer be negligent in his work and escape, okay, while the clearing agent is cornered for his own mistakes? And that's why I'm saying that I think it is good to look at this more broadly and be able to, and KIFWA must be able to put its foot down and say that when our members are declared correctly and on time, and there's a delay at KPA, there's a delay at KRA, at KFIS, and whoever is causing that delay, especially, for instance, where you have to go, like today you went to KRA on valuation, you won. What if it had taken a week, okay? Now, if it had taken a week and you had 10 containers, what would be the demurrage that you would incur, all the storage that you incur? How does KRA compensate you for the faults of its employees? That's what I'm asking.